very much. So what I indicated what I was going to do is to go to particular paragraphs and closings.
Yeah.
If my comments are too oblique and you don't understand, because I'm trying to be too, as it were, abbreviated, will you say? Likewise, if you've already got the point, I'm not precious about being told, got it.
Okay, that's fine.
Awesome. Yeah. Can I just draw your attention, first of all, in the group's closing submissions to paragraph 2?
Yeah.
Mr. Covington is quite right. The BNAG group are not signatories to the Statement of Common Ground. They are, however, a Rule 6 party, and therefore bound by both the requirements of the procedure related to Rule 6 statements. The group provided a very extensive Rule 6 statement. I've got it in my hand now, just so that you should have some indication of the length of it. You will look in vain for any reference to a failure to comply with the waste hierarchy or any submission made with regard to waste wood. The submissions which followed were all opportunistic and not rooted in the case which was presented in the appropriate way. If you could go then, please, to paragraph 16. This is a theme which recurs between both Mr. Fraser and Mr. Cunnington. Here are the matters which it said give rise to a public perception of risk to health and the environment. And they're there set out. And it said at paragraph 17 that none of those crossed the boundary into EA areas of concern. The difficulty for both Mr. Fraser and Mr. Cunnington is that every single one of the points they rely on with regard to what supports objectively the public perception relates either directly or indirectly to the exercise by the agency of its regulatory function. And you will have heard that. You hear it in some of the references that Mr. Fraser gave to cross-examination, Mr. Oath, and you hear it in what Mr. Cunnington says, and you hear it in terms of the cynicism expressed with regard to the agency in the response to submissions that I've made to you quite recently about the agency and their regulation of the process. It is not consistent with the Secretary of State's policy to say we accept that the regulatory framework will be properly controlled and will operate effectively, and then to say we have public concerns about health which arise from the fact that the process may not be controlled in the way the agency should. Those are inconsistent with the Secretary of State's policy. Paragraph 24. It is said in the first sentence that it's therefore evident that the appellant has firmly based its entire case in respect of sustainability and compliance with the principles of the waste hierarchy proposal on a supposition that the relevant type of waste would be available in the region in sufficient volumes to meet its stated needs. That is not so. We rely upon no supposition. We rely upon estimations of waste wood availability, and importantly, from yours and the Secretary of State's point of view, we rely upon and are entitled to rely upon the absence of any indication from the authority who collect all the statistical data with regard to waste arisings in Manchester and who operate the relevant up-to-date waste local plan, who give no indication whatsoever that, firstly, there will not be any waste wood or sufficient waste wood to support the proposal, and secondly, that it might in some way offend the waste hierarchy. Paragraph 28. And 29, we can take together. This is dealing with the core strategy and Mrs. Harding's position. In paragraph 29, referring to the core strategy and demonstrating the proposal's consistency with the principles of the waste hierarchy. The problem with this submission is very simple. The person relied upon in the group's submissions for the evidence is Mrs. Harding. Mrs. Harding is instructed on behalf of the Council. The Council has agreed expressly and without qualification that the proposal complies with the regional strategy policy related to the waste hierarchy. That is policy EN11. So core document 63, EN11. There can, on the basis that the core strategy has been prepared in conformity with the regional strategy, therefore be no doubt whatsoever that the Council has agreed that the proposal complies with the waste hierarchy. The fact that subsequently Mr. Watson may have gone on some frolic of his own with regard to the availability of waste wood avails the Council nothing. I'll deal with Mr. Fraser's submissions in regard to the waste wood later on. Paragraph 33. I confess I'm mystified by the paragraph. Mr. Cunnington will forgive me. He says the general statement of purpose contained in the Joint Waste Development Plan document provides that it's intended to provide a sound spatial framework to deliver sustainable waste policies consistent with national policy and the waste strategy. Contrary to the submissions of the appellants, it's submitted that both documents should be afforded material waste by the inspector. May I make it clear that fundamental to our submissions to you is the proposition that you should give full weight to the Joint Waste Development Plan document and the Waste Strategy 2007. And in giving full weight to them, you should bear in mind that the most relevant, or in legal terms, dominant policy, that is policy 10 in the Joint Waste Development Plan document, is a policy in respect of which the appellants made detailed submissions, core document 15A, section 2. And in respect of those detailed submissions, the plan-making authority, the body with the knowledge with regard to local waste matters, specifically endorsed the approach in core document 15A, see core document 40, and the second letter, that is the letter of the 11th of March. On that basis, as we've indicated, the proposal complies with what the group says is a document to which great weight should be given. So it should. It's a section 38.6 document and is the most up-to-date element of the development plan. Paragraph 36. And perhaps also 37, which is dealing with Mr. Watson's evidence. This is all embraced by my earlier submission that the group is now well outside its statement of case. and embarking on an opportunistic exercise to try and take into account Mr. Watson's evidence. I'm going to deal with the DEFRA report at this point. I shan't deal with it again when dealing with Mr. Fraser's submissions, because the same points arise. You may take your pick, core document 80 or core document 94, doesn't matter. But both Mr. Cunnington and Mr. Fraser say this is the most up-to-date document. This is the place to which you should look for some accurate indication of the availability of waste wood. Neither, I must say, appears very keen in the submissions made to you to draw your attention to page 1 and the executive summary. And in particular, to the third paragraph. You'll get the flavour from just the first sentence. The data on wood waste, particularly on the amount going to landfill or informal markets, is not clear. That's the starting point. That's the predication for what is, I remind you, a call for evidence. It is a call for evidence because DEFRA says, in essence, it doesn't have the evidence and it's not clear. What DEFRA is seeking to achieve is exactly what this proposal seeks to achieve. Fourth paragraph of the executive summary, a drive away from landfilling wood. May I then draw your attention, and I'll do it without any lengthy recital, to the purpose of the call for evidence at page 2. Paragraphs 23 and 24. With references to export of waste wood from the UK, paragraph 23. Paragraph 24, the destination of the remaining tonnage remains unclear. To page 8 and figure 3. The key box, wood fraction of mixed waste estimate is how it's described. The figures are described in the source as provisional. And to questions 3, 4 and 5 on page 8, all of which indicate, if you needed any further indication, just how little data there is and how unclear it is. Confirmation of the export position is provided on page 15. And question 7. Material is going to export. It's not going to export because there isn't enough of it to fuel proposals of this kind. You go to paragraph 42 then, please. This is a comment on the AEA document produced by Mr. Singleton in his rebuttal. I hardly, I hope, need say what AEA's expertise is in this area. What their report does is exactly what is relevant from your point of view. That is to point out that estimations of the availability of waste wood are just that, estimations. There are significant difficulties in obtaining the data, that is entirely in accord with core document 80. Unclear. Paragraph 44. This is another opportunistic foray by Mr. Cunnington into the CHP area. The difficulty both the Council and the group have with regard to CHP is that the Environment Agency have specifically considered it. And they haven't considered it because it was simply of passing interest. As you'll see from core document 67B and page 23, and the first complete paragraph on page 23, the SGN and the WID both require that as well as maximising the primary use of heat to generate electricity, waste heat should be recovered as far as practicable by identifying and utilising opportunities for combined heat and power and district heating. I won't read the remainder of what's on page 23, but you'll see that it was a formal and, in that sense, legal part of what the agency were doing to consider whether this proposal was, as far as practicable, recovering waste heat. You will know what the agency's conclusion was. You also note the reference at page 135, which deals with the proposal being in an appropriate location from a CHP point of view. I'll return to that aspect with Mr. Fraser's submissions because the Council has other difficulties with its now alleged Policy 8 lack of compliance. Paragraph 48. The last sentence of paragraph 48. The proposal will be sufficiently proximate to residential suburban areas to justify the finding from the first ground for refusal of planning permission by the LPA. That is a submission which is made contrary to an up-to-date development plan which the group itself says should be accorded significant weight. That's because the development plan was prepared on a basis which regarded 250 metres as being a distance which was a satisfactory separation between waste management facilities, including thermal treatment facilities, and either individual dwellings or settlements. The group's submission, therefore, puts them in conflict with the development plan. Paragraph 56. This is a paragraph which ends with the words that, if not the entirety of the AQMA, are being subjected to levels of nitrogen dioxide which are in excess of the lawful limits. There is not only no evidence to support that submission, there is evidence directly to the contrary, which is uncontroverted. That's the evidence contained in Mr. Othen's main proof of evidence and the plans at Appendix 2, which show the air quality management area and indicate, by reference to monitoring stations, where levels are above or below 40 micrograms a metre cube. The submission is wrong.
Yeah.
Paragraph 57. The end of the paragraph. It said at the end of 57, even if the contribution of the proposal to the levels of nitrogen dioxide in the area is in itself of a modest nature, and there is a dispute as to its extent, contribution needs to be weighed in the context of already unacceptable conditions. Well, I've dealt with the already unacceptable conditions just a moment ago, but the dispute as to the extent of the contribution of the proposal is a dispute within very, very narrow limits. On any basis, contribution is negligible. There is no evidence to the contrary. When paragraph 58 therefore says that the proposal will contribute to unacceptable levels of pollution, that's not supportable by reference to any material contribution from the proposal. Paragraph 59.3. The appellant elected not to undertake any background monitoring of the air quality at projected areas of likely worse concentration. I think it should be air quality, not area quality. Yes, good. Air quality at projected areas of likely worse concentration. The reasons for that were given by Mr. Oath, explained in detail by reference to what the major contributor to poor air quality is, that is traffic. And those reasons are supported by the conclusions of the agency, Trafford Borough Council and Dr. Broomfield as to the adequacy of the available monitoring data in order to properly assess the impact or lack of impact of the proposal. There's a reference at 59.5 to Liverpool Road. Now, I remind you that Mr. Oatham doesn't stand alone with regard to his conclusions in relation to Liverpool Road. That's a conclusion which is also supported by the agency, specifically having considered the readings from Liverpool Road. See page 41 of core document 67B. Paragraph 59.7. This is still with additional monitoring in the second half of the paragraph. It's not therefore understood how the suggestion that it was unreasonable to expect such work to have been performed is made out by the appellant. See Mr. Oatham's answers and the confirmation of his position from every independent, qualified contributor to the process that I referred to a few moments ago. Paragraph 59.8. Paragraphs 5 and 7, Dr. Holman's proof recommended as giving the most reliable evidence to the objective basis for public concern the likely impact of the proposal in the context of the uncertainty as to the pre-existing base levels of nitrogen dioxide concentration. This uncertainty is uncertainty within, we respectfully submit, a very narrow ambit. And it's an uncertainty which, when characterized by the agency in their independent review, led to the conclusion at the top of page 43 of core document 67B. This is another example of where what the group seeks to do is, on the one hand, say, well, we know we're supposed to regard the permitting regime, the planning regime as separate, but we want to attack the way in which the permitting regime is operated and given this proposal a permit. So we attack the agency's work in relation to the permit. That is not an appropriate honouring of the clear distinction that the Secretary of State says should be in place and should be respected in the planning regime. The same point arises with regard to paragraph 61. paragraph 61 is a direct attack on the permit and the permitting regime and its operation in this instance. What it amounts to saying is, we don't think the Environment Agency have done their job properly. We don't. You can hear you can hear exactly what I'm saying. The basis for the perceptions is, we don't believe the agency have done their job properly, and we don't believe the agency will do it properly in the future.
Exactly.
And that is an approach which is directly in conflict with paragraphs 27, 28 of PPS 10.
That was about people.
Just finally, when you get to the end, to page 20, you'll want to ask yourself to what extent these submissions have grappled with the fact of the permit, with the fact of the HPA having raised no objection, having undertaken a site-specific consideration of the proposal, and therefore with what the Secretary of State says is the right approach in paragraphs 27 to 31 of PPS 10, having been effectively honoured by the appellants in the approach that they've adopted. I've nothing further to say about those submissions. I could then take up Mr. Fraser's submissions, and I start with where I left off with Mr. Cunnington's. You'll no doubt, I won't say at leisure, but enjoy a read through these submissions at some stage in your consideration when writing your report. You might just care at the beginning to have by you your pad and write down references to Environment Agency permit in VFQC submissions. I can promise you, you will not have to write a lot down. These submissions turn their back on the regulatory regime which operates to protect the environment and public health. Turn their back on that regime, and they do so because my learned friend, I suspect, recognises that the moment he has to engage with it is the moment at which this house of cards collapses. So if I may, more particularly, page 2 at the end of a very long paragraph 4. All of these submissions about the Council's case and where it was or was not set out might be helped, might they, if when we got to the statement of case we could find that the Council had set out some conflict with some policy other than WD5 of the by then expired UDP. The fact is that the statement of case simply doesn't go there. It confines itself to a very narrow compass. It says harm to economic regeneration and public perception. And that's the end of it, with no policy support. As a side wind at the end of this particular section of the submission, Mr. Fraser said that the appellants themselves had said that little weight should be accorded to the Joint Waste Development Plan document. What he didn't tell you was that that point was made in core document 15A at a point at which the Joint Waste Development Plan document was much earlier in its preparation than the time when this matter was reported to committee, which was highly relevant to weight. Paragraph 7. Paragraph 7 elides the careful distinction drawn in the Statement of Common Ground between particular policies. Policies 4, 5 and 8 of the waste plan are dealt with in the Statement of Common Ground. And they're dealt with at page 40, paragraph 852 and 853. The policies, that is 4, 5 and 8, are simply recited with no suggestion that the Council contends a conflict and no suggestion that they will need to be dealt with in evidence. In relation to policy 10, at paragraph 855, it is said compliance with this policy will be dealt with in evidence. So in the Statement of Common Ground, the Council's position was quite clear. It did not contend that policy 8 would need to be dealt with. It recited its terms, but no more. In particular, no conflict. At paragraph 9, there's a reference to the Council's statement of case and whether the proposal constituted sustainable development. The ambit of that submission will be clear to you from the statement of case, and the absence of any reference to waste wood as a consideration, or the waste hierarchy as being a consideration. The same point arises with regard to paragraph 11. The main issue is no one, until the arrival of Mr. Watson's proof of evidence, no one involved with this inquiry imagined that we would need in any way to engage with the availability of waste wood. It had not featured in any inquiry document as being an issue. Thus it is that what follows from paragraph 12 is the new case. It has a difficulty. The difficulty is one I've referred to already and only briefly now cross-referred to. The difficulty is this, that at its heart it suggests a conflict with the waste hierarchy. At one and the same time, in the Statement of Common Ground, the Council has assented to the proposition that this proposal accords with the policy in the regional strategy that addresses the waste hierarchy. I've drawn your attention to the importance that attaches to the Statement of Common Ground in these proceedings. I don't repeat it. Over the page, please. Page 6. Here we have an attempt to explain something about the Statement of Common Ground with references to what might or might not be surprising. I say only this, that what is surprising is that this submission should be made in circumstances where the Statement of Common Ground has addressed fuel type and delivery. At page 12 and paragraphs 418 and 419, without any dissent, 418 and 419 are agreed paragraphs, not appellant's view, but agreed paragraphs. They say where the fuel will, what the fuel will comprise of. The same can be said about paragraph 7.9 on page 23. An agreed paragraph with its references to stimulating, opening up supply lines, and demand for biomass fuel will stimulate an increase in its supply. No contention that there's no supply to be had, so it doesn't make any difference. And the final reference, page 25, paragraph 717. The aspirational targets set out within the strategy, that's the biomass strategy for the Northwest, reflect the significant potential that exists given the underutilised biomass fuel supply within the region. That, as an agreed statement, is completely inconsistent with the case the Council now wishes to run. Page 7, paragraph 15. This is all still waste wood to landfill. And this is the DEFRA report, core document 80, making its appearance. I won't repeat the submissions I've made to you already about that document, and I don't therefore have anything further to say about that. If you could go to page 8, please. Paragraph 20, the same point arises with regard to the DEFRA document. With regard to paragraph 21, it's clear that the newspaper or website articles have got under the skin of Mr. Watson. And here are the submissions giving the evidence of that. The fact is that those articles, you will see, are not offered as some quantitative estimation of the availability of waste wood, but very simply a marketplace comment on the very significant supplies of waste wood that are available. Yes, some of them may be about the southeast, but there is nothing unique in terms of waste wood production about the southeast, as opposed to a major conurbation like Manchester. The articles also support the view that there are very substantial exports of material. Material is being exported because it cannot find a use in this country, not because there's a lack of it. Page 9 and the continuation of paragraph 21 and paragraph 21.6, the Sonai plant. With the closure of Sonai, a very large amount of waste wood wants a market. It is, with all due respect, completely nonsensical to say that if it can't find a market in the board manufacturers because Sonai is gone, that it should be tipped into a landfill rather than used in a recovery process such as electricity generation. Page 10 and the Peel statement of paragraph 22. Perish the thought that the real world should intrude on this forensic analysis of a lot of unclear figures. But the Peel statement produced by Mr. Singleton is a real world statement by someone operating in the real world with regard to wood supplies. It makes the very simple point that a very great deal of time and a great deal of money would not be expended pursuing the proposal, for which fuel would not be available in accordance with the strategy identified. The same is true with regard to the Hatfield Wood Recyclers statement. Here there is a forensic analysis of a letter which is clear as to what it means and what it is trying to say. I invite you to read the letter, note its content, and note the substantive support it provides for the AEA report position and the appellant's position. Paragraph 24. The cross-references Statement of Common Ground, paragraph 7.9. Paragraph 27, the appeal should be determined on the basis of the latest information and data. The latest information and data is held by the GMGU. There is no body or other organisation in the Northwest better equipped to consider whether or not waste would be available to support this proposal. You know what their views are. Page 30. And we're now into the continuing expansion of the Council's case, at this time CHP and Policy 8 of the Waste Plan. This submission of paragraph 33 simply fails to grasp and deal with paragraph 237 of the Waste Policy Review, called Document 77. That's the paragraph that says that the evidence indicates that in advance of plant being built, and therefore the real availability of heat, it's very difficult to get people to engage. That's the most up-to-date statement of the government's position. The Council doesn't address it. Paragraph 38, page 14. Now, try now to take a number of references here. A very great deal of time was devoted in this submission to examining the extent to which the proposal was in or not in either Ernstton or some other area. The appellant's position recorded in Mrs. Harding's proof of evidence, I think the reference is paragraph 5.3.7, is exactly that set out in the Statement of Common Ground at paragraph 8.23. And that is, the core strategy splits Trafford into 10 spatial profiles. Whilst the appeal site is not explicitly located in any specific spatial profile area, it sits in between the defined areas of Trafford Park and Ernstton. Later in the submission, Mr. Fraser attempts to tell us that that language means something other than what it says. I'm happy for you to judge it.
Okay, well, I think I've got enough information.
Yeah. And the cross-reference, as I said, Mrs. Harding agreed with us, 5.37. 5.47, I think, so it's 5.4.7. So when Mr. Fraser submits paragraph 41, that Mr. Singleton's approach has some very obvious flaws. They're flaws, if such they can be characterised, which are evident in the Statement of Common Ground and evident in Mrs. Harding's evidence. That's paragraph 43 is where that was dealt with. And so we say the submission of paragraph 44, Mr. Singleton spent so much time arguing something which is plainly unarguable. Mr. Singleton simply relied on what the Council had agreed in the Statement of Common Ground. We then move to the regeneration part of the Council's case, page 18. And this is a continuation of paragraph 45. And this comment applies to paragraph 45.4 and paragraph 55.1, Mr. Fraser's submissions, where you will notice that he's managed to refer to a substantial number of unlet retail units or the level of vacancy without telling you that the vacancy rate in Urnston is substantially below the national average. And that takes into account Victoria Parade. There is, accordingly, no basis whatsoever for suggesting that Urnston's health as a centre is fragile, or that it has been in any way affected by this proposal. Then paragraph 46, and I'll try and take here by reference to the submissions made in relation to Mr. Hetherington's evidence, a number of points that are made here and later on in the submissions. It's very important to see that Mr. Hetherington's evidence is essentially factual. He records, from a perspective of an experienced chartered surveyor, he records sales rates, prices, and looks at what has happened at different sites. He considers whether, on the basis of that, looking at those factual matters, there is anything to indicate that the raft of adverse publicity about this proposal over now a period of years has had any material impact, and he provides a conclusion. The first question I invite you to ask yourself when you read these submissions that attack that conclusion is, where is the factual evidence which undoes what Mr. Hetherington says? Secondly, to ask, where is the council's evidence on any other basis to indicate that there has in fact been some adverse effect on house prices or the rate of sale? There is none. So what we have is a sustained attack on a piece of evidence which is essentially factual, with nothing put against it. That doesn't, of course, mean that you have to accept Mr. Hetherington's evidence. But in the circumstances, you ought perhaps to think hard and long before rejecting it, bearing in mind the ample opportunity that the council has had to get such information if it could. Page 22. And paragraphs 52 and 53 are embraced by the submission which I've just made to you. I don't add anything further. Those paragraphs are covered by it. Paragraph 55.1, I've already pointed out what the vacancy rate is, the absence of a reference to it. The only point I would add with regard to then the detailed consideration of individual sites, points to add are, firstly, there is no evidence from any of the developers involved in any of these sites that are, on any basis, local or proximate to the appeal proposal to indicate from the developer that there has been some difficulty. So, for example, Persimmon, Barton Cross, no evidence. As far as Cadishead is concerned, I'm perfectly content for you to go and look and see whether or not you think it's an appropriate comparator. And in relation to the generality of the other proposals, you will have understood that our point is the point which was essentially being made by Mr. Robinson at Sinfid Lane, Mr. Singleton's Appendix 7 and paragraph 61. That is, that developers would not be pursuing these proposals and spending the money doing so if they thought no one was going to buy the houses. my earlier submissions with regard to the evidence are particularly poignant in the light of Mr. Fraser's paragraph 56, which seeks to put, as it were, the burden the other way round. The appellant has not produced any evidence which suggests, still less establishes, that development in the area of concern has not been affected by the appeal proposal. You might just like to ask yourself, supposing I turn that round, has the council produced any evidence to establish in the area of concern that development has been affected?
Okay.
To which the answer is no.
Not Bill.
There then follows a deconstruction with regard to the New Haven study, which I say with great respect to Mr. Fraser, is positively Delphic in its approach to the inspector who dealt with the proposal in Sussex. Because one of the things that was not drawn to your attention, Mr. Singleton, rebuttal appendices A, paragraph 2235 of the report, is the inspector's conclusion with regard to the North Andover study, that is, the Keel-McLean study, and whether it had any relevance from his point of view. Paragraph 2235 makes it clear beyond a peradventure that he considered it irrelevant for reasons which were very clearly set out. And having considered it, he said, I do not find it demonstrated by this research that the incinerators that cause the industry to be there or the house prices to be lower. At the same time, the inspector had to consider the DTZ report, paragraph 2233. He did so without criticism of the proposal. So a clear rejection of the report relied on. A clear acceptance of the report referred to by Mr. Singleton and dealt with in the Cornwall appeal decision. At paragraph 63, page 29, Mr. Fraser says, third line, second sentence, there are good grounds for concluding the appeal proposal would reduce the attractiveness of the surrounding area as a place to live and invest. A little later on, paragraph 74, on page 33, he says, 4 lines up from the bottom of the paragraph, the physical presence of the proposal and the processes associated with it would adversely affect the area, and in particular the perception of the area and confidence in the area as a place to invest.
Yes.
Physical presence adversely affect, and attractiveness of the surrounding area adversely affected. That's a submission which needs to be read alongside the conclusions contained in the statement of common ground agreed with the Council, in particular in section 9 of the statement of common ground. You'll recollect that those cover ecology, noise and vibration, landscape and visual impact, transport, external design, hydrology and soils and ground conditions. Particularly with regard to appearance, we'd invite you to note landscape and visual interest and the conclusion of paragraph 9 and 11, and external design, the conclusion of paragraph 920. The full suite of paragraph references are 9.4, 9.11, 9.16, 9.20 and 9.24. Against the background of agreement about those matters, it is not tenable to suggest that the physical presence of this proposal will be anything other than entirely appropriate in its context as a matter of agreement with the Council. And if you want to check, sir, whether I'm right, that's a matter of agreement. You can
I'm familiar with what it says in the statement of common
Thank you very much. Just one minor matter of page 31, paragraph 68. I don't think that's an RTPI article. It's actually simply an article written in Planning Magazine. You may well have seen it. At paragraph 32, page 32, paragraph 70, the end of the paragraph in dealing with the Cornwall decision, Mr. Fraser says this decision, it's clear, was heavily influenced by the context of the proposal, and in particular the fact that the proposal was sited in an area which was already severely impacted by tips and clay workings. Well, I've re-examined about that, and in that same context I draw attention to what I've just drawn to your attention with regard to this proposal and what's agreed about it with regard to any impacts. We then move to impact on air quality and perceptions, effect on human health. And paragraph 76, which continues on to page 34. In the continuation of paragraph 76, it said that the appellant also placed heavy reliance on the plant being a modern, well-regulated facility, but it agreed that this does not of itself answer the perception issue, does not in itself relate public fears and perception, just as with the issue of impact on regeneration and so on. This is another example of an approach which turns its back on the Secretary of State's guidance in PPS 10. One cannot, on the one hand, say the guidance in PPS 10 is clear. We should proceed on the basis that the regulatory regime will work and the regulator will do its job. And then, on the other hand, say, but we're entitled to feed our perceptions on the basis that the regulator won't do its job. Feed our perceptions on the basis that the regulator will fail and the process will not operate in accordance with its permit. Those two submissions are fundamentally inconsistent. And that's a theme which runs throughout this section of the submissions. They do not grapple, the submissions that is, do not grapple with the fact that perceptions which rely upon the regulator failing, the regulatory regime failing, are not legitimate ones to take into account in the planning context. Paragraph 83 on page 36. You've got the detailed evidence with regard to ill health or the lack of it. And we saw in re-examination, Mr. Oath, just what limited areas were affected by the lower levels of the indices within Barton. But I remind you, if I may, that this submission gains no support whatsoever from either the HPA or, perhaps more relevantly in this context, the local health authority. And that position with regard to those very limited areas being areas of deprivation is to be contrasted with the Blue NG position, where the adjoining 3 complete wards were areas of significant deprivation. Paragraph 85 and the EA reference is dealt with by Core Document 67B, page 43, and the first complete paragraph at the top of the page. Paragraph 86 is all we're entitled to rely on perceptions, and perceptions which are fed by the regulator failing, and is accordingly not a legitimate approach. Page 38, paragraph 88. This is an attempt to get behind the DEFRA submission, formal submission, to the European Commission. And I remind you that that submission was formally submitted not some years ago, but in 2011. And as Mr. Otham confirmed, submitted on the basis of presenting the most up-to-date and accurate information to the Commission, in circumstances where the Commission would be looking to see whether there was the prospect of infraction proceedings. Paragraph 91. The opening sentence is nothing if not bold, but with all due respect, not correct, at least in its bold implication. The extent to which nitrogen dioxide levels are above the AQO in the AQMA, I've dealt with already. It doesn't support this submission. And the extent to which some people within the area will be subject to those levels is limited, and as the agency indicated, in any event, any contribution from this proposal would be negligible. Paragraph 93 is perhaps the most explicit reference that we find to an attempt to put PPS 10, paragraph 27 and 28 guidance to one side and say that if you're talking about perceptions, you're entitled to feed the perceptions on the basis of a failing regulator. And I draw it to your attention in the context of the submissions that I've already made. Paragraph 94 draws attention to a broader view of health effects. I remind you that the Health Protection Agency could hardly be unaware of what might be termed a health effect, and you have their views. At paragraph 95, my learned friend prays in aid Mr. Watson's evidence and the DEFRA indications with regard to what might cause anxiety with regard to risks. And that's sourced as Mr. Watson's paragraph 254. The source is quite correct, but what my learned friend doesn't do is to point out that the report which Mr. Watson relies on at paragraph 254 is the same report that's described at paragraph 198 of the same proof of evidence as being no longer up to date and in some aspects demonstrably incorrect. Page 42. Paragraph 98. Professor Bridges' evidence happily chimes with the position of the Health Protection Agency. Neither the HPA nor Professor Bridges' evidence provides any basis for regarding the impacts referred to as being significant or of a kind which would entitle the Secretary of State to disregard his own guidance. 43. Paragraph 101. This is the HPA advice. The HPA advice, you'll see from paragraph 101, for submissions, middle of the paragraph, their advice is that small studies of public health around incinerators are not recommended. And at 102, that they recognise there are public concerns about this issue. And it makes reference to the fact that there has been a further study commissioned. Now I remind you that both in the Sinfin Lane decision and in the Battlefield Enterprise Park decision, the fact of an additional study being commissioned was expressly addressed and rejected, as the HPA themselves have rejected it, as a basis for suggesting the current advice is not appropriate. Page 44, paragraph 105. This is about the stack height. The stack height in relation to the current proposal has been expressly considered on a site-specific basis, and it has been concluded, firstly, that it is banked at its best available technique, and secondly, that it is Waste Incineration Directive compliant. Those matters are site-specific and proposal-specific. Ince Marshes is an example of another site and specific, proposal-specific consideration of appropriate chimney height. It avails nothing to draw attention to the difference. With regard to paragraph 108, I remind you that the agency, as part of their remit for the permit, has expressly reviewed the combustion process, whether or not SNCR is banked, and whether it's likely to be achievable. And in core document 67B, expressly concluded on a process-related issue, that is, a permit issue, that it is not, I respectfully submit, the function of this inquiry to review that. Paragraph 110 suggests that we're dealing with what's described as abnormally low levels, and that feeding uncertainty in terms of public perception and anxiety. That's a regulatory matter, dealt with by the regulatory regime, addressed by the permit. It's not an appropriate matter now to say, effectively, as I indicated earlier, we don't believe what the permit says or what the agency is saying. Paragraph 111 deals with traffic. Traffic was screened out of the assessment process with the agreement of the Council as being an insignificant matter. Blue NG is addressed on pages 46 and then on 47. I remind you that that was an actual impact case. With regard to the HPA's position, paragraphs 115 and following, I invite you to look at the HPA's conclusion of their specific advice, core document 34, and see whether or not you can find any caveat with regard to any health effect related to nitrogen dioxide or indeed any other relevant chemical. There is no caveat. The construction which is being put on the HPA advice amounts to a submission that the HPA has abdicated its responsibility with regard to a health impact to a local planning authority who've been told by the Secretary of State that they shouldn't engage themselves with these health matters but should take advice from the HPA. The that is with all due respect, nonsensical position to be advancing. And finally, page 48, and the continuation of paragraph 119. This is my own friend dealing with the framework, paragraph 124. At the top of page 48, we are told planning decisions should ensure that any new development in air quality management areas is consistent with the local air quality action plan. The proposal fails to comply with this guidance and is a further respect in which it fails to satisfy the framework and fails to represent sustainable development as set out in the framework. That, if I may respectfully say so, is a submission which is not just not supported by evidence, but contrary to the evidence given by Mr. Watson. I put it in terms to Mr. Watson that there was no suggestion that this proposal conflicted with the local air quality action plan, and that was agreed. Dr. Holman made no suggestion to the contrary. So that in terms of a framework policy, this proposal finds, as with other policies, a happy consistency. I invite you to reject that, and indeed the other submissions made. Thank you very much.
Thank you. Okay, well that completes the consideration of the planning cases inquiry. How's the principal parties, if there are any other matters to wish to raise?
No, no, the fact that I understand that public would like you to see that and to read that, and so consequently having seen what it is, happy to have it associated with a letter that goes with it.
It's a late submission, so
It's a late submission.
Okay.
I suspect your children are rather old for the book now, but you'll at least enjoy memory lane.
Okay, thank you very much. Okay, so I've got the only copy, have I?
You have.
Okay, you're happy about that? You've
Yes,
seen it?
yes, we've seen it.
That's fine. Okay.
You asked about other matters.
Yeah.
It's right that I should say that my clients have given very careful consideration as to whether or not there should be an application for costs. Peel are a company that's embedded in this community in all sorts of ways, as you will gather. That they've taken the view, notwithstanding what they regard as a robust position with regard to an application being made, that they would not wish to make one. Accordingly, there will not be an application for costs. Thank you, sir.
Thank you. Okay, Mr. Fraser, anything? No? Mr. Cunnington? No. Okay, thank you very much. Just a couple of administrative matters then, before I make a final word of announcement. One is to do with documents that I've received. Has there been an updated list, or is this something that we can...
I'm not sure. I haven't seen an updated list from the one that I think we had.
No, okay. Well, I mean, I can update it myself. I think it's probably the best thing to do with all the documents that I've received today. But can I just mention documents that have appeared on my desk during the course of today? I have one from Mr. Cliff. Do you have that?
Yes.
One from Kath Edgar, who we spoke this morning. Some email ones which came over the weekend, which I don't think I need to trouble you with. From a further response by Dr. Hans Christian Raven, 26th of November 2012. You seen that?
No, I don't think I have seen that.
I think they were put out this afternoon, Mr. Kingston, at the same time as the dinosaur book, I think.
As far as I know, we dealt with all that I thought we had seen from Dr. Ravi, and for obvious reasons, we've been keen to try and keep up with that to ensure that you had our view on it. If you have some new submission which we haven't seen, then we've not had an opportunity of addressing it.
Well, there's a document on my desk, and I don't know to what extent it's been circulated, 26th of November 2012.
I can't help you with that, sir, but as far as I know, we've responded to any of Dr. Ravi's documents that we had in time to
and then one from Mr. Kilbert. Which is an abstract, and one from a final statement by Mr. Greener. Have you seen that?
Yes, I've just been given that.
Yeah. Okay. But the same comments apply.
Yes, I've just seen it. So I have no idea what's in it or whether or not a response is called for.
No, okay. I mean, they have been submitted very late in the day, and clearly there hasn't been an opportunity for the parties to consider the issues that arise. So, on that basis, I think the weight that can be given to them is extremely limited.
Well, so I make it quite clear that if you or the Secretary of State attaches any weight to any submission that we've not had the opportunity of answering, I shall object.
Yes, okay. I understand that.
Thank you very much.
Chairman,
Mr. Greenough?
can I just say that I submitted my document immediately after lunch. I just want to let you know that.
Immediately after lunch today, yeah. But, I mean, there have been other things going on, as you know, and the council have been very busy, so they haven't had an opportunity to consider any substantive matters that arise. Okay, anything else?
Only the site visit. So we distributed last week a plan with in a form that you may have seen before.
Yeah.
Which contains, as far as we've been able to ascertain, all the viewpoints that you've been asked to look at by everybody, with a suggested route, in order to assist you and others then in deciding how it might be done in a way that would avoid knowing where everyone was going.
Yeah.
We haven't had a response to it yet. It's a matter entirely for you how you organise the site visit, but we were keen, as far as we're able to help, first of all to provide the map, and secondly, organise a route if that would be helpful.
Okay, well that certainly would be helpful. I thought there had been ongoing discussions, and I indicated that I'm happy to do a number of sites unaccompanied, but equally, if it helps, then I'm happy to be accompanied to the principal viewpoints that have been identified. I mean, can I just suggest that we meet at 10 o'clock tomorrow, whoever's going to be coming. So who is it from Peel? Will it be Mr. England from Peel?
Yes,
Mr. Kilbert, and from the council. Perhaps you could have some further discussion about where we might go overnight.
And Mr. Diggle will come as well.
Okay, Mr. Diggle.
Singleton's associate.
Yes, that's fine. So long as we've got a representative from each group in each car, there's no problem. Can we meet at 10 o'clock tomorrow? I don't know if it's... I believe there's a match here tomorrow, so it's probably not appropriate to meet here, I don't think. I was wondering whether we could meet, when we went on the preliminary side, we met by the security box on the... on the access road to the wastewater treatment plant, and I wondered if we could meet there to save everybody coming into.
BK's viewpoint 10.
Can you tell me where that is? Is that
George Parnell Leisure Centre, where the community south is the appropriate place to meet is near us.
okay? There's parking there, so I can leave my car. Yeah. Well, just after the inquiry closes, somebody can just show me where that is, and I'll meet whoever it is there at 10 o'clock.
Yes, it's on your plan as viewpoint 10, and so
okay.
I'll give you this.
Thanks very much, then I know. Right, 10 o'clock then tomorrow for the site visit. Okay, just a couple of things I wanted to say. Can I make a personal word of thanks to Michelle Cody, who's been extremely helpful throughout proceedings, a programme officer in all but name, really, and a very friendly face. Well, everybody to the inquiry, so I am very grateful for that. I think when you weren't terribly well a couple of weeks ago, Natalie helped out, so pass on my thanks to her. And I'm aware that other people have been running around in the background trying to make everything run smoothly, and I'm grateful to them as well, so they know who they are. And then I just wanted to say thank you very much to all participants, to Council, Mr. Kingston, Mr. Fraser, Mr. Cunnington, their witnesses and teams, to members of the public for the way they've approached the inquiry, which has been helpful to me, and I think it's gone well. At least from my perspective. I hope it has from your perspective as well. So I was just going to say that on occasion over the past couple of weeks I've sometimes felt as if I've been watching the grass grow, but actually that's been during the breaks where I've been sitting upstairs in the executive boxes overlooking the pitch, and you can literally watch the grass grow. You can hear it.
Considerable expense, they say.
Yeah, and all the back combing and manicuring and general titivation that goes on as well.
I hadn't realised you'd seen Mr. Fraser having his hair cut.
Well, that's something that did escape me. Anyway, yeah, I just want to say thank you very much, and wish you all well.
I'm sure we'd all like to say thank you to you for your patient and good-tempered oversight of the inquiry, which has made it, from all our points of view, I think, much pleasanter than it might otherwise have been. Thank you very much indeed.
Thanks very much. Thanks.
Excuse
I
me.
wish you all well. And,
Richard, could I just say on behalf of the Breathe Clean Air Group, thank you so much. You've been absolutely wonderful. Thank you.
thanks, that's kind. I appreciate
Thank
that.
you.
So the inquiry is now